Yeah, I need that. For myself.
Children laughing.
Doing good. Kids gone for 2 weeks.
No, they
What you
always
do last
have
night?
meetings. Didn't you know that?
Yes, you do. In here?
I had a plan.
All the meetings. When Lee
That's what I say to everybody else.
before we
Oh, yeah. Daydreaming, sitting
Online. I
there.
thought you were talking about
Watching TV.
what you want to watch. When you want to watch it.
I was giving you my son.
All right, welcome to the Asheville City Council work session devoted to the issue of city council districts. We don't have a flag, so we're not going to do a pledge tonight. That was my first question. Okay, so for this evening's format, it will be as follows. Our city attorney, Brad Branham, as you can see, already has loaded up here a presentation that he is going to make, and he will talk a little bit about what that will include and sort of some caveats there to start with. I would anticipate that there may be some questions from the council as well as the audience about the content of the presentation. So what we've decided to do tonight is kind of a two-part format. We will have 3x5 cards to pass around and for people to put down any questions you have about the presentation portion of the meeting. So if you hear something and you don't quite understand it, or you want to expand on something, or whatever the case may be, jot your question down on a 3x5 card. At the conclusion of the presentation, we'll take a short break. Brad will have a chance to kind of look through those cards, and then we'll try to get, to the extent possible, those questions answered. Then we will open it up for the public hearing portion of the meeting, where you will have 3 minutes to tell us your thoughts on this topic. So hopefully that makes sense. We just wanted to make sure you didn't have to spend your 3 minutes part asking clarification questions or trying to better understand the presentation portion. Okay, so with that, the first thing we need to have is a motion to suspend the rules in order to allow for public comment during a work session. Do I have a motion?
So moved.
Second.
All right, we have a motion and a second. All those in favor, please say aye. Aye. Any opposed? Okay. And so with that, I will turn it over to the city attorney, and you're making, do you want to? Oh, I'm sorry. Please silence your cell phones. Oh my God.
Was that you?
Yes, for example.
Okay. Good evening, Mayor, members of council. As you said, my name is Brad Branham, Asheville City Attorney. At the request of this council, I'm going to come before you tonight to give a little presentation specifically regarding the impacts of the recent state legislation, commonly referred to as Senate Bill 813, the effect that had on our local municipal elections, as well as then provide this council with the legal and legislative options that it has at its disposal to deal with the effect of that legislation. Now, as I go through this presentation, I'm going to do my very best to condense this down to a form that's both digestible and actionable. Certainly, I will be prepared to answer any questions at the end of this. I will say that in preparation for this presentation, I have thoroughly reviewed, researched the applicable law. I've spoken to numerous attorneys around the state who are experts in this particular field, as well as other experts in various aspects of potential claims or other legislative options that the city may have. I am not a specific election law expert. I must give that caveat to start with, but I feel more than competent to address this issue. If the council or the public has certain questions that are beyond the scope of my ability to answer, I will certainly try to get that to council at a later date. Now, I will, as I said, do my best to condense this. I've tried to prepare a presentation that is short and concise enough, but with being specific enough so that council has the information it needs to both consider and decide the path forward that it wishes to take. I will say that this is an area of law that is rather extensive and it is somewhat complex. Constitutional law does not have a history or a reputation of being terribly simple. However, I will do my very best to highlight the areas that I think are important. What I will not do during this presentation is provide any specific recommendations or legal opinions to council about what it should do in this case. The presentation is in the format of an information session to give you the information you need to begin to lead to the second step, which is diving more specifically into your decision process about what, if any, avenues you would like to take. There are perhaps some more appropriate forums for those particular conversations and some additional experts that we could bring in to assist council in that process. However, I believe what you will see tonight should get you well on the way towards that second step of analysis. Now, again, I do this tonight as an information session only and not an opinion session, specifically for a very important reason. In order to protect the integrity of the attorney-client privilege, the necessary confidentiality that this council would need with its attorney, if any future lawsuits or claims were filed, means that we must absolutely begin protecting that privilege right now. So we can share information, but we need to stop short of opinions. So I may reiterate that during the course of this presentation or in answers to any specific questions. But that being said, I'd like to dive in and start with this presentation. Oops. Before we get into any sort of detail about options that this council may have, it is always important to start any conversation with regard to the relationship between state and local powers with a quick statement, two sentences actually, one directly from the North Carolina Constitution and one from some relevant case law, which essentially tells us what we need to know as a starting point with regard to the powers of the state and the powers of the cities within that state. So per the North Carolina Constitution, cities and counties, such as ourselves, are creatures of the state. We are created by the state, and the state, per our Constitution, has almost total authority to provide for the organization and government, including sort of fixing boundaries of the cities. That is a very big blanket statement saying that the state has a lot of power. The state was given this power via the Constitution of our state to allow for them, as the state, to both create cities, to change cities, and even to eliminate cities if they so chose. It is a very, very broad power. The second sentence comes directly from some relevant case law, which says municipalities have no inherent powers. They have only such powers as are delegated by the legislature to it, which means that, as the council knows, we are always limited in what we are able to do. As the state has broad power, we have limited power, and it's simply the makeup of the kind of law that is our state's law regarding municipalities. So with that in mind, we can dive in. First of all, and I think it's important to understand what it is we're talking about here. In 2017, the state legislature began a process to implement some changes to our local charter. A city's charter is essentially like its own constitution. It says how you are elected, what powers you have, among a variety of other things. Senate Bill 813 made some very specific changes to our local charter. It was ratified last year in June, and because of that, we can look very specifically now at the changes that were made in that bill that matter. First of all, where were we before Senate Bill 813? 4 important points. Prior to the bill, all city council members were elected at large, meaning they were elected from anywhere in the city by everyone in the city. Elections were nonpartisan, and they were done through a primary process, meaning we had a primary and then an election. City council elections were always held in odd-numbered years, and the terms of council were 4 years and staggered. Now, after the bill, where we are today, city is no longer at large. We've been divided into 5 separate election districts. 1 council member is to be elected from each district, and 1 council member will be elected at large, and the mayor will continue to be elected at large. The elections are nonpartisan, using the plurality method, which is a bit of a fancy way to say leading vote getter. No primary. The primary has been removed as part of this bill. Elections are to be held in even-numbered years instead of odd-numbered years. All terms remain 4 years and staggered. So what does this mean for us? Right now, based upon the new law that the state passed, the next city council election is scheduled not for this year, as had been the practice in the past, but instead in 2020 and then again in 2022. Only general elections will be held and no primaries to accompany those elections. 5 candidates will be elected from districts in which they reside by the voters in those districts. In other words, voters in District 1 will only be able to vote for the candidate from District 1. The mayor and 1 at-large council member will continue to be elected under the old system, which is fully at-large. There is no effect in the bill on the duration of the council's term limits or that they are staggered. The one difference, which is an exception only in this first year, is that every council member essentially receives 1 additional year to your term because elections were moved out 1 year under the new bill. So that is where we stand today based upon the state's new law. We can now pivot and say, what are your options if you choose to act? I believe council has approximately 4 options here, and I'm going to lay out these in more depth as we go through this presentation, but we can say that council's options are these. It can do nothing. Second, council can act unilaterally to amend its charter. Again, the charter is what has been amended by the state law. Council in this city has the unilateral authority to do that itself. Council can file a claim challenging some aspect or all of the new law. That is another way of saying filing a lawsuit. And finally, council can exercise some combination of those options. Now, I'm going to talk about each one of these in more depth. The first one does not require a lot of discussion. It's pretty simple. If council so chooses to do absolutely nothing, we are where I just said we were, which means that the city's charter will remain changed by Senate Bill 813. There's no council elections this year. The next council election would take place in 2020, followed by 2022. No primaries would be had. 5 districts, as they are currently drawn, would remain in effect. The city would, however, maintain its right to do a charter amendment in the future. It would also maintain its right to file a claim, although there is likely certain statutes of limitation that would apply, and we would probably be banned from doing any sort of litigation action after June of 2021. Now, I'm going to go into each one of these options that are a little more specific in detail. Going into option number 2, council's second option above doing nothing is that it has the right to amend its charter. Pursuant to North Carolina General Statute 168-102, the legislature has given us, as a city, the authority to amend our own charter. The state clearly has the power to do that, but so do we. And by amending the charter, the city actually has the power to be much more surgical about what it wants to do. The city can elect to do a total change of several of the aspects of the new election system, or it can choose a variety of options. Council has the ability to amend its charter to turn all council seats back to at-large elections, or you can select a variety of different district formats, including something similar to what the state imposed if it so chose. Council can have partisan or nonpartisan elections. It can have a primary or it can have no primary. There is, however, one limitation to this. There is nothing in the state statutes that would allow this council or any other council to amend the year that the elections are held in. That is one aspect that the state law changed, which is a power not given to councils in this state. Although you can change all of these other items and pick and choose and have a variety of those changes, there is no provision to allow cities to change the year via a charter amendment of their elections. Now, I believe that based upon some of the comments that we've heard from council to this point, there are 2 primary options that council may want to consider when and if it chooses to amend its charter. First of all, the amendment could simply reinstate all council seats to at-large elections using the nonpartisan primary election method, essentially returning us almost back exactly to what existed before Senate Bill 813. The one difference being that elections would remain in even years. Second, if council chose to maintain districts, it could do so, but it could reinstate the primaries as part of that. Now, districts, as I've had a note here, can also be modified if council so chose to keep the districts, but allow for all of the district representatives to be elected by all of the citizens of the voting citizens of Asheville. In other words, every citizen would get to vote for every district member. So that's another option. There are others. There's a variety of options, and I won't go over all of them, but these are some of the ones that I believe might be of interest to council. Again, you have the ability to pick and choose, like a menu. Primaries, no primaries, district, no districts, what kind of districts, at large. It is a very precise process that council can dive into in order to determine its form of government.
Brad, we also have the ability to decide how big or small we are too, right?
It's a good question. It wasn't listed in the presentation, but among the options that I've already provided, council has the authority to make other changes, including decreasing or increasing the size of council. The only limitation on that is that council must be at least 3 seats and no more than 12. So we do have the ability, as part of this charter amendment, to change the size of council. There are several important considerations to keep in mind with regard to amending the charter. First of all, any charter amendment must remain in place for at least 2 years following the election and the beginning of the term of anyone elected under that system. So what does that mean to us? If council chose to amend the charter in any way that as we've discussed, the system put in place must remain in effect not just through the 2020 election, but also through the 2022 election. And that, again, is a state statute forcing that change to remain in effect for that period of time. Second, any amendment must be adopted and finalized by this council at least 90 days before the election. And remember that that is the election, either a primary or a general election. So it's something to keep in mind. Third, council may, but it is not required to make any such amendment subject to a public referendum. That is council's choice. However, the citizens have the right to issue a petition to force that under certain circumstances. Finally, I've noted that I'll get there. Any charter amendment that the council makes, similar to the fact that the General Assembly just amended our charter, would still be subject to future amendments by the General Assembly. In other words, they changed what we had. We can change what they did, but they maintain the right to change what we may do in the future.
Brad, can I ask you a question about that? If you can go back. So if we change our charter and then they change our charter, are we then, can we then change our charter again? Or are we still stuck by this 2-year rule?
So the 2-year rule applies specifically under 160A under the statutes, which prescribes the authority of municipalities to alter their charter. I do not believe that if the state legislature changed any amendment that we made, that we would be obligated under that 2-year time frame. And I think council would have the right to immediately do their own change yet again.
Change it again. And I've got one other question about this option, and that is that, so the right of local governments to change their charter is contained in a statute.
It is.
Not in the Constitution. And so
No.
could they change the statute to take that right away from presumably all municipalities then?
It is a possibility. The General Assembly is the overseer of our state statutes. They are the writers and the changers of those bodies of law. They would have the right potentially to do that. What I would say is that it would be very difficult for them to do that in an Asheville-specific way. I believe that you are probably going to get beyond the pale, and you may see some of that reasoning later on in the presentation. However, if they tried to impose such a thing on a statewide basis, it is a possibility. That is something that, in my mind, I have never seen them go quite so far, but I must say that it is a possibility.
But I would add that it has been typical that they do restrict the local government's right to redistrict themselves when they do a local redistricting bill. We're actually the first one that they didn't do that to. And when they districted Buncombe County commissioners, and remember, for those who weren't here, that we used to have 5 at-large Buncombe County commissioners, and they changed it to 7 and put 2 commissioners in each of 3 districts. They restricted the right of Buncombe County to use this methodology that applies to counties for a period of 20 years. And there was never any challenge to that. That just stood. And when they redistricted Greensboro, they also took away this right as well, and that was what Greensboro's challenge was based on. So we're kind of the guinea pig, if you will, in that they did not remove this right in our situation.
Yes, and thank you, Mayor, for that, because I do want to highlight some of those points. The General Assembly, as we started from my first slide saying, has a lot of power. They, like anyone else, is limited based upon the Constitution, and that's really the federal Constitution. There are certain rights that they simply can't infringe upon, and when they take it a step too far, they should and usually are challenged on those things. Some of the things that we're talking about in terms of what they could do in a hypothetical sense may give rise to very obvious constitutional 14th Amendment challenges if they removed rights, especially in an Asheville-centric way. Now, closing up the portion of the presentation regarding a charter amendment, there are certain pros and cons that I think are generally important for consideration by the council. First and foremost, a charter amendment is something you can do unilaterally. It requires no permission from the General Assembly. It requires no consent, and it requires no lawsuit or other litigation methodology. There is a process very specifically prescribed in the statutes that allow this council to act all on its own to do this. Secondarily, the action can address as much or as little as you would like, other than the change in election years, which is not a power given to us. Council can change its size, council can change its makeup, districts or at large, partisan or unpartisan, primary or no primary, or any combination thereof. So it's something that council has the ability to be much more precise in what it wants to do. And finally, and perhaps most importantly, a charter amendment does have the added benefit of avoiding litigation costs. There is simply no way to file many lawsuits without litigation costs along the way, as well as the risk that you may not be successful. With a charter amendment, those things are off the table. The cons, however, are important as well. As we've already stated, an amendment could be undone by the state, which means what we do may not be final. Secondarily, as I think everyone would recognize, such an action may start a chain reaction, which could result in additional provocation from the General Assembly. Now we'll move on to option number 3, filing a claim. Now, before we really go into what sorts of claims I think are available to the city in a litigation context, I think it's really important for us to examine a couple of seminal cases that are out there in the state of North Carolina. We've heard about these cases. It is very, very important for us to think about how, if at all, these cases apply to us and what lessons we can take from it. The first of these such cases was the city of Greensboro, which the mayor already mentioned, versus the Guilford County Board of Education. Just going to make a few points about these cases for context. First and foremost, it's important to note that in that case, the state legislature passed some law to change existing city council districts. The districts themselves already existed. After the case, the districts continued to exist. It's something of note because that's different from our particular situation. But the state also did something else. Other than redrawing the district lines, it also, in the legislation, removed the right of citizens of Greensboro to have a referendum to change their charter, exactly what we've been talking about. And although the state and the Board of Education really provided absolutely no defense for themselves in this case, the court found fairly easily that by taking away that referendum right, the state legislature had gone too far. And they determined that that was a violation of the 14th Amendment. Now, it's important to note why the court decided to rule for Greensboro and why they did not. This case had absolutely no findings regarding the districts themselves or even how the districts were drawn. It was only the second aspect of the state law that the court said was no good. You cannot, per the case law now, take away that right of referendum from a single municipality when other municipalities have it. So it was under that theory that Greensboro was successful in the case, not based upon districts or the imposition of districts, as would be the case for Asheville. The second case, which is very important, happened over in Wake County, and this was the Raleigh-Wake Citizens Association versus the Wake County Board of Education. Again, in this case, you had a state legislature impose a new law, and what it did was redraw the county commissioners' districts and the Board of Education districts. Now, again, in that case, those districts already existed prior to the new law. They exist after the new law. The problem was the way that they were drawn. And in that particular case, the group of citizens who formed this association as the plaintiff in the case said that the way they were drawn essentially amounted to either political gerrymandering or racial gerrymandering. So those were the claims that were made. Now, the court held in this particular case that the way the districts were redrawn was a violation of the Equal Protection Clause of the 14th Amendment under the doctrine of one person, one vote. Now, we may talk about this in great detail, but at least I want to say that the one person, one vote doctrine essentially says that everyone's vote should count the same. If by any way that districts are drawn or election formats are done, if someone's vote begins to count much less than someone else, you're going to have a violation of the one person, one vote. A good way to think about this is if you drew a district with 10 people in it, and you drew a second district with 100 people in it, and each one of those districts were allowed to elect one council person. The people with 10 voters have much more power per person than the people with 100 people in their district. That's sort of the thought behind one person, one vote. And the rule is talked about in depth in this case, and what it essentially says is when you have districts like this, the population deviations between the districts need to be within 10%. Maybe one is 5% above the average, one is 5% below. That's going to be generally okay. If you get outside of these deviations of over 10%, there is an assumption that there's something wrong with that law. Somebody has had their vote diluted or disenfranchised by that law. So that's what we look at, that 10% deviation. Now, in this particular case, the districts were drawn within the 10% deviation, so it looked okay to start with. The way courts look at these is they say if you're within 10% between the districts in population, there is a presumption of validity. It's probably okay. If you're outside of that 10%, there's probably a problem, okay? But even if you are within the 10% and it's presumed valid, this court held that if the districts were drawn based upon illegitimate reapportionment factors, another fancy way to say bad intentions, you still may have a problem under one person, one vote. So the first thing you look at is the population deviations, and if it's beyond 10%, there's probably a problem. If it's under 10%, there still may be a problem if the rationale behind the way they are drawn is based upon illegitimate factors. That's what happened in this particular case. Although they were within that 10%, the presumption being that it's okay, in this case, the court found that there was fairly rampant political gerrymandering. And in that particular case, again, the court found in favor of the plaintiffs. Now, it is important to note here again that, as I said initially, they also made a claim for racial gerrymandering. Like Greensboro, the court made no finding on the racial gerrymandering in this case, only on the political gerrymandering. So
you better clarify that the
Yes.
court that made this decision on the political gerrymandering was not the U.S. Supreme Court.
That is very
was
good. It's a
the
very good
North
point.
Carolina Supreme Court.
And I can say that both of these courts, in the Greensboro and in the Wake case, were both federal courts. They were not state courts. And both of these actually happened prior to last week's Supreme Court decision as well.
So this case was in federal court, but it was not appealed or was not, or they didn't take the appeal?
This was at the Court of Appeal level for the final decision.
That would be the Fourth Circuit.
Yeah,
now it's got,
this was the Fourth Circuit, yes.
well, now, I mean, the U.S. Supreme Court has effectively overruled it, but it wasn't the case directly on it.
It is important to note, and as we have seen last week, and this is a good time to talk about this, the U.S. Supreme Court has now weighed in on racial and political gerrymandering, and essentially has told us that no matter how bad it looks, and even with a recognition of how bad it may look, they believe the courts, at least at the federal level, don't have the power to do much about it. And in fact, the Supreme Court specifically said the following, that the districts in those two cases, which were North Carolina and Maryland, the districts at issue here are highly partisan by any measure, and that excessive partisanship leads to results that reasonably seem unjust. The issue of partisan gerrymandering is a non-justiciable political question outside of the scope of judicial review. So based upon this new finding by the Supreme Court, The hurdle to address any kind of gerrymandering in the federal courts has been greatly restricted at this point.
Brad,
Yes.
based on the decision on the Supreme Court, is that specifically just the federal courts, as they would want states to kind of govern themselves?
It's an excellent question. So the limitation that was discussed in the courts was that this was a federal court decision, meaning that it has not been restricted in state courts. And in fact, at least the North Carolina plaintiffs are going to proceed, I believe, in state court. We do have in our state a constitution that has similar provisions to the 14th Amendment of our U.S. Constitution, where those claims may still exist. What the court has really said is they believe this is really an issue for legislatures to deal with instead of courts.
So does that preclude us from pursuing a state Supreme Court?
I do not believe that the Supreme Court of the U.S.'s decision immediately and automatically precludes us from state court options. It may certainly create an additional hurdle, but it is not a closed door.
So my understanding is that the North Carolina case goes to trial in a week or so, 2 weeks maybe, on this very question.
Soon, very soon, yes. So it may be a while before we reach a final decision on that, but the process is well underway.
For folks who don't follow, like maybe you and I or anybody else up here, can you clarify for folks in the audience what Julie and I are talking about?
Yes, so specifically, there were two claims made, one in North Carolina, one in Maryland, regarding the newly drawn, in both of those states, state election districts. So these are for the state legislatures in those two states. There was a claim in North Carolina that the current Republican legislature had essentially gerrymandered the districts to provide for almost perpetual political advantage. The same claim was made in Maryland, although in that case it's a Democratic legislature in place. The challenge was made under the 14th Amendment that people's votes had been diminished, sort of under this one person, one vote rule, which is what we've been talking about. And that wound its way up through a variety of federal courts to the Supreme Court. And then just last week, the Supreme Court essentially said it looks bad, but we don't think the courts are the right party to handle this. Now they're going to take up their claim in state court. So that being said, now that we've seen some of these cases, a couple of quick takeaways. Very important for our particular situation. In both of those cases, election districts already existed. The legislature did not impose districts in either of those cases. What they did was redraw the districts, as well as some other activities. That's a difference that we need to keep in mind. Secondarily, after the fact, even though both plaintiffs were successful, under neither circumstance did the court remove the districts. They simply said you have to redraw the districts to fix the problem. Those are two important takeaways with regard to these cases that are out there. Now, I believe, based upon the current law, even in regard to the legislation, or excuse me, the court decision from the Supreme Court earlier this week, that this council, if it chose to litigate these claims, would have three primary avenues to do so. Those three claims are, first, a standard equal protection claim, a la what we saw in Greensboro. I'm going to call that general discrimination. Second, a claim under the one person, one vote claim, which is similar to what we saw in Wake County. I'm going to call that diluting the votes. And finally, a claim under racial gerrymandering or Voting Rights Act federal law. I'll call that racial discrimination. So essentially, the three claims are general discrimination, racial discrimination, and diluting the votes. All of these claims arise under the same constitutional provision, which again was what we just saw in the Supreme Court on the 14th Amendment. So let's talk about option A, an equal protection claim.
Before you move
Yes,
on
Counsel.
to option A, so backing up to what you just said, so if we were to pursue those claims, what court would we pursue those claims in?
We have the option to pursue it in either court. You do not have to start in the federal court as some of those other claims did. You could start in the state court.
So we
I think
could
that would
start-
come down to a strategic decision.
Right. That's all I wanted to ask. Thank you.
Thank you. So in discussing option A, again, this is general discrimination. The legal standard in order to prove a claim under this theory The city would have to prove that it has been treated differently from others who are similarly situated to us as a result of intentional or purposeful discrimination. If this was proved, the burden would shift to the state to defend itself, and the state must then show that it had a rational basis to put the law in place that it did. Now, I know that this gets into very legalese stuff, so I'm going to try to pare that down just a little bit. Basically, what happened in Greensboro? In Greensboro, the legislature took away a referendum right, only from Greensboro and from no one else. The court found that that was discrimination specifically against Greensboro. The other citizens, similarly situated in other municipalities, maintained that right when Greensboro lost it. That's that general discrimination. It wasn't against a particular racial group. It was the city as a whole, but that city alone. No other cities were forced with that. And that was clearly very intentional, very purposeful from the legislature. They put it in the bill. We're taking this away. So it's easy to prove. Now, I have to say that all of this is judged under one of two standards by the courts. Either a low bar, which we call rational basis, or a very high bar, which is called strict scrutiny. Now, without getting into too much of the details about this, if you are generally discriminated against, this first claim, the legislature only has to meet the low bar and show that they had a rational basis to do what they did. And the law says as long as they can really come up with some kind of legitimate government purpose to have the law in place, that's enough. It is a very, very easy standard based upon case law out there for the General Assembly to meet. And they could say something along the lines of, we wanted to put communities together and this looked like good lines to draw. As long as it's not intentionally discriminatory, it's difficult to prove these claims with that low rational basis standard. The higher bar, the strict scrutiny bar, only applies if the discrimination is against a suspect class, i.e. think a class, a racial class or some similar class that has been historically been suppressed, or if there is a fundamental right that's been affected. And we won't get into what fundamental rights are, but in Greensboro, it was decided that the right of a referendum was not a fundamental right. Again, it's why they had that low bar that the state, in that case, still couldn't meet, but still a very low bar.
And Brad, in that case, they didn't meet it because they didn't defend it, too,
The-
right? I mean,
the
so
state-
we don't even know in that case because they didn't have anyone show up.
The state did not show up to defend itself. The Board of Election filed a cursory answer, but didn't defend itself either. It was very easy, I think, in that case, for the court to say, you did enough.
Because they had no basis.
They had no basis.
They
showed-
claimed no basis.
They offered no evidence whatsoever into the case.
Yeah.
Now, as we can see here, you have to go through this framework of analysis, which is difficult, as is any constitutional law claim. But it gives you a sense that in order to have this kind of a claim, the city has to prove something, i.e. that we were intentionally or purposely discriminated against. And then if we do, the state is still okay if it can show it had a rational basis to do what it did. If either of those fail, then that side loses. Now, without going into a lot of details, I think it's always important to say, what does a claim like this cost? With any lawsuit, you're going to have a great deal of leeway or spectrum on how much a lawsuit could in fact cost. But I've spoken to several attorneys throughout the state who specialize in these kind of claims, and I can give you a rough estimate to say that what they're telling me is $500,000 or more in order to litigate one of these types of claims based upon past practice.
Brad, before you move on.
Yes.
So on the threshold question of whether Asheville could prove whether it's been treated differently, I mean, the mere fact that there was a bill passed that did this to us, and in that particular session, not a bill passed that was where it was done to anyone else, would that be sufficient, do you think, to meet that, like our burden of proof that would then shift it, or does it have to be something additional?
It's a very good question. So in answering that question, I think we have to, again, go back to that first slide that I talked about. And remember that our state has great power via the North Carolina Constitution. Right. We look at the Greensboro case. In Greensboro, they redrew the districts there. That court said nothing about that being an issue.
Right.
The court said the issue there, the discrimination, was in removal of that referendum right. So we don't have that in our law here in Senate Bill 813. The city would have to determine what, if any, aspects of the law produce that level or similar discrimination.
Right.
For that burden then to be shifted to the state.
Thanks.
So we go to option number B, or option letter B. This, we've talked about general discrimination. This is that one person, one vote. I call diluting the vote, making some people's votes count for less than others. Think the Wake case. That's what happened there. The legal standard here, again, is you first look at the populations in the districts themselves. If they're within 10%, there is a presumption that those are probably okay, and no one's vote is counting for less than anyone else's. If it's over 10%, you probably have a problem there. Now, if you're under 10%, as they were in Wake County, you can still sustain a claim if you can show, as you see under my first bullet, if the city could prove that improper or illegitimate considerations predominate the reasons for the new law. Again, even if you're within 10%, if the new law was based on really bad intentions and that was the primary factors for drawing the lines the way that they were, you can still sustain a claim even though population deviations aren't off.
Brad, would it matter, or would the courts take into consideration if you had a district that tended to have more people vote? Not that the voting population was different, but that one district tended to have more history of voting. Does that matter? Or not?
I don't think it matters under the law. I think this is based upon all potential voters, not all actual voters. Now, once you've looked at that initial prong, do the districts have populations that are relatively the same? If they don't, there may be an issue. If it is, you then turn to that second element. Was the reasons they are drawn the way that they are based upon bad stuff, bad intentions, improper or illegitimate consideration? Now, of note, courts have said very specifically that attacks in the forms of lawsuits on deviations that are under 10% will succeed only rarely in unusual cases. What this is the courts telling us that if they're within 10%, we're going to assume pretty strongly that the legislature was right and make it very, very tough for municipalities to sustain or citizens to sustain a valid claim. It can be done, and it was done in Wake County, but it's a tough row to hoe. Now, it is also important to note in this particular case that as I stand here, I cannot tell you that our population deviations are within or without that 10% threshold. The bottom line is that the numbers that the legislature used were based on the census from 2010. We're nearly a decade removed at this point. Not only that, but there was quite a bit of annexation that happened in this city between the time that those numbers were created.
Not quite a bit.
Well, potentially significant amount.
Some.
My legalese, Mayor. It is important to note this only to say that the lines that were drawn by the legislature were based upon numbers that are now nearly a decade old. No one can say where our numbers are specifically until the next census comes out. We won't receive those numbers until several months into 2021, which would be after the next election at least. Now, at that point, this council is required to redraw its districts anyway as part of the standard process every time a census is done. So it is worth noting that at this point, there are potential anomalies that may need to be looked at in order to determine whether or not that 10% threshold is an issue or not. That sort of analysis is outside of my legal capabilities. I point it out for consideration.
So Brad, just let's play that out, right? So let's say we go with this claim. We say we allege that we have a deviation over 10%. Let's make the allegation. The court's going to turn around and say, you got to show me something, right? And then we're going to say, well, we don't have the census data yet. We're going back in 2010. And so, they filed a motion to dismiss, right? Or say it's not ripe, right?
It is a very good point. It is a very good point.
Right?
Well, what I would say is that we can certainly do a certain amount of analysis and estimation right now. The question is this going to be close? Are we really talking about something that's between 9 and 11%? We'll probably never be able to get down to those kind of specific numbers without a census. If you did some estimations and it looks like it's 15% or more, then you may have something just based upon the estimates. But again, it's outside of my ability to weigh in on that. We do have experts in the field who can do these kind of analysis, and I would encourage council to, if the choice was to go down this path, that would be the first step to begin looking more closely at those numbers.
And Brad, again, remedy here is to redraw the districts, right? It's not to.
It's a
blow
very
out the
good
system,
point.
right?
It's a very good point. The judicial remedy, if you have a one-person, one-vote problem, think about it. What we're saying is these people in this district, their vote doesn't count as much as the people in this district. You remedy that under the case law by courts saying redraw those districts and fix the problem. There is no precedent for eliminating the districts based upon this.
Brad, I have a clarifying question about your second to last bullet point, where it states, courts have said that the attacks on the deviations under 10% will succeed only rarely in unusual cases. When you say courts, can you clarify if it's federal court or if it's state court? Because at this point in time, our federal court, Supreme Court, is really different compared to our state Supreme Court.
Agreed, and I can say specifically that line comes straight out of federal case law.
Not state.
Not North Carolina State Court. That's exactly right. And this is something that, for those who understand, we have two different court systems in our country. We have our state court system and our federal court system. And one does not automatically bind the other. There may be some looking at that and some precedent, but just because something was decided in federal does not mean it's the law in state court automatically.
I just wanted to clarify because our state court, the makeup and decisions that have happened over the recent times here are totally different than what our Supreme Court would be.
It is a good point, and that language came directly out of federal court.
I would agree completely. We as a city already have experienced this difference, but I think what I'm hearing you say is, let's say you win. The remedy the court can give you is the redrawing of your districts.
That's correct, and that's exactly where I wanted to go with this. It's not only important to think how you prove a claim, but what do you get if you win? So we talked about that first claim, which was general discrimination. That's what happened in Greensboro. In that case, they were able to set the full law aside because the law was flawed. It was constitutionally flawed. In a one-person, one-vote, if your districts are drawn such that some people aren't having the same voting power as someone else, the courts step in and the remedy is to redraw the districts. Correct the error, not throw out the law. That's the way courts handle those cases.
And in the Greensboro case, they already had districts, so it just reverted.
That's exactly right. They went back to their old districts. And the same thing happened in the Wake case, in fact. And this was the standard applied, this one person, one vote, exactly to that case, that they were drawn incorrectly. That was the problem. The solution via the courts, redraw those districts, correct that disparity. So finally, I will again note that I've done my best to talk to some attorneys who handle these kind of cases to get a rough idea of what the cost for these kind of claims would be. Again, you could be seeing upwards of $500,000. I have put a lower amount on there if you want to consider $100,000 low. And that is really based upon the possibility that you would simply do a statistical analysis and find very quickly that you're probably within that 10% ratio. And if you did, you may decide that that claim would not be worth pursuing, and you might be able to quickly get to the point where you would have the data you would need to make decisions. But a fully litigated claim, you're probably back on the high end of the spectrum.
So Brad, sorry, before you go on. So our case is a little bit different, as you've said, from the Greensboro and the Wake County cases, in that we didn't start with districts. And so in your conversations with attorneys about this, are there cases in other states that are more similar to this, where the remedy might be to actually go back to no districts as opposed to redraw the lines? Is there any precedent for that anywhere?
It is difficult for us to look too much into other states. And the reason for that is every state has a separate constitutional power granted to the municipality and
Well,
the
let
state.
me amend my question. I guess I mean cases in federal court that have come out of other districts.
Yeah. The vast majority of cases where you have a 14th Amendment problem, which is saying someone has a right that is being discriminated against, most of those cases as it relates to what we'll call a broad gerrymandering of election districts. The remedy in almost all of those cases, the vast majority, is to fix the discrimination, not to throw the law out.
see.
Now, there is some small sliver of an avenue that allows for the entire law to be thrown out. And that's really what happened in the Greensboro case.
But that was a different claim. that
It
got
was a
thrown
different
out.
claim, and you had something that had gone beyond just the districts themselves. What we can say is that the state, as well as the city council, has the right to impose or remove districts. That right exists for both of those entities under the law of our state. Just having districts is legal.
That's right.
Removing districts is legal. How they are drawn creates a potential problem under the 14th Amendment, and the corrective action is to fix the way that they are drawn.
Got it.
That's why most all of these courts are going to impose a redrawing as opposed to removing the law.
So, say what you just said again. I mean,
How far back should I start,
No,
Vice
no.
Mayor?
Right, exactly. Go back. I've missed everything. Thanks a lot, Brad.
Slide one.
Yeah, slide one. I'm not an attorney. So in the law right now in North Carolina, it's implicit that the state legislature has the right to impose districts on a county or a city. I mean, that's an implicit right.
Article 7, Section 2 of our state constitution gives that and also a very broad authority specifically to the legislature to set up the boundaries and form of local governments. And that's where that authority comes from. Our city council has that right via Chapter 160A of our state statutes. But that is a right that the state had that they gave to us.
And the second question I have is, and I'm sure you would have told us this, but has there ever been a situation where a city or a county has gone, when districts have been initiated into a city or a county, has any city or county gone back and successfully argued with the legislature and got those districts removed?
I can't speak to every case in every state on that. What I can say.
North Carolina.
In North Carolina, currently, I believe that, not including Asheville, there are 5 other municipalities. There are, I can't remember the exact number, but the vast majority of municipalities over a certain size are currently using election districts. In almost all of those cases, it was a request of the municipality to have the legislature impose a district upon them. I am not aware currently of any case where the districts themselves have been challenged by a municipality in the state, but I cannot speak to any potential claim. There may be something out there, but I'm not familiar with it.
So you're saying no other municipality had them imposed at their objection?
Well, may have objected, but I can't think of a case where a municipality has challenged the imposition of districts and been successful to remove the districts. In the 2 cases that we hear about the most, which are the Greensboro and the Wake County case, both of those already had districts that just got redone.
But I thought I heard you say that the others that it was imposed on requested that.
In some of those cases, they did. The municipality asked for it.
It's hard to believe, but the way it used to work is the city went to the legislature and requested some assistance, and then they got bills passed that responded to that request. That was the typical thing, how it would be done.
A world gone by, but that is how this often happened. And local municipalities Oftentimes, historically, in order to avoid certain gerrymandering that they saw or political gerrymandering, they went and asked for districts in order to protect against that, to provide for areas where different groups would be able to have more power as opposed to being drowned out by completely at-large elections. So now, where we stand today, I don't know, Councilman Haynes, of a specific case in North Carolina where the imposition of districts was then challenged and then the districts were removed in this state. It may have occurred, but I'm not familiar with it. Now, moving on to the final slide. We've been through the final claim. We've been through general discrimination. We've been through diluting the vote. The last potential claim out there is what I would call racial gerrymandering, or a claim under the federal law, which is the Voting Rights Act. Now, in order to sustain a claim for racial gerrymandering, the city must prove, under the case law, that the predominant factor motivating the way that the districts are drawn and the shapes that they take was race and not something else. In addition, the city would have to prove that the legislature subordinated traditional district race-neutral principles. Instead, they used racial motivations to draw those districts. That's pretty easy to understand. If you're trying to racially gerrymander, you're going to focus on how do we subvert this particular race's voting rights. The city would have to prove that that in fact happened. Now, again, as with all the other claims, once the city proved that, the burden shifts to the state to defend itself. And in this case, because you have what's called a suspect class under the law, that higher bar that we talked about, strict scrutiny, is applied to the state's rationale. They must meet a very high bar. Why did you do this? Why did you put this law into place? And they are required to have that law be very narrowly tailored to achieve a compelling state interest. That's much harder for them to show, okay? Because under the law, we want to protect against this particular kind of discrimination, so they better have a very good reason for doing it. So that's the legal framework that you analyze these cases under. Now, the law under, again, under federal case law, where most of these cases come from, cases have said that even shaping districts for purely political motivation is enough to defeat a claim for racial gerrymandering. Now, I'm going to repeat that because it sounds counterintuitive. But the case law has said, if you tell us that you are trying to give your political party an advantage, that's enough of a reason to say that it wasn't racial gerrymandering. And then you're going to, and you're going to be back under that lower standard, which is rational basis again. This is a very good example of why these particular claims in our current judicial system are difficult. Because it is very easy, you can even say, I wanted my party to have an advantage. And that's why I think there's more Democrats or Republicans or whatever other party. But if it's not based on race, that's enough to have that lower standard for the state to have to meet. It makes these claims particularly difficult. And you can see that in what's just happened, in part, with our U.S. Supreme Court decision. Now, under the Voting Rights Act, and we've been talking about the 14th Amendment. That's all U.S. Constitution. This is a very specific area of law which was designed years ago specifically to protect people's votes from being attacked, primarily African Americans, where there were many systems in place limiting their power of vote. So this was put into place. A claim under the Voting Rights Act requires the city to show that the minority group that we believe has been disenfranchised, first and foremost, is sufficiently large and geographically compact enough to constitute a majority in one of the existing or potential districts. This is what is difficult for Asheville under our current makeup. If we're talking about potential racial gerrymandering for African Americans, you have to be able to show under the case law that there is a sufficient population of that group in order to be a majority in a particular district. Based upon our current population, that's going to be a difficult bar to get over. And that is the first element that you must prove in order to have a claim under this particular federal statute. Now, in addition, and this is also very important, both under this claim as well as traditional 14th Amendment racial gerrymandering claims, the way that you determine whether or not you've been injured by the law is generally backward looking. What that means is you go through an election and see what the result is. Almost all the case law out there says what happened in the election as your proof of were there really racial gerrymandering in place, or was that not really a factor? It is very, very difficult to sustain one of these claims prior to going through an election. It is very much like suing someone whose car is pointed toward you, but before they've hit you. Now, this would be difficult to do, as I've said, prior to an actual election. Now, finally, these cases of the three claims that we talked about are some of the most specialized. They require very particular experts who can do the kind of social analytical analysis that you need to go through in order to have expert witness and testimony. Because of that, these cases are often the very most expensive of these types of claims. And some of the quotes that I've received from throughout the state go anywhere from $500,000 to $2 million to litigate this kind of a claim through the courts.
Brad, remedy again here is what?
The same as what we talked about with one person, one vote. If you are talking about some particular district that's been drawn in such a way as to hurt someone's rights or dilute their vote, racially or politically or otherwise, the remedy the courts allow is to redraw, correct the district. That's what courts do here. And they would simply, again, likely order that the districts be redrawn. That's what they've done time and time again.
I have a question.
Yes.
So we could essentially amend our charter, and also while doing so, say we were to want to keep districts or whatever, we could also redraw the maps through the amendment.
That is absolutely right. And in fact, I will say, it's a requirement on us after every census to redraw those districts. So it's something that this council has to do if it has any districts in place within the next 2 years anyway.
And we would also then have to meet that 10% test, right?
Exactly, exactly. Now,
But we would have the updated. Sure.
you would have new census data, yes. So basically, I know we've talked about a lot, and I know constitutional law can be a difficult thing. We've only gone as far as I think we need to at this stage to begin thinking about these things in our context. But basically, here's a couple of pros and cons for you to keep in mind. With regard to filing a claim, the city can challenge all aspects of the law. You can, in fact, challenge the entirety of the law itself. Although, as we've talked about, we would have to find a basis for that, similar to what Greensboro did with that referendum right. Now, we don't have that in our case, so we would be in a somewhat unprecedented situation trying to make a claim to challenge the entire law. Second, if successful, some of the changes might be barred from any future action. Now, the mayor mentioned earlier on in the presentation that if we amended our charter, the state could come back and amend the charter yet again. Well, if the state tried to do something to remove that right from us, I think we would certainly want to argue very quickly that we had been done as Greensboro had been done, and they had removed a right from us which was beyond their constitutional authority to do. So those kind of things, I think what's happened in Greensboro now has been barred from them doing it again. There are several likely cons as well. First of all, as we've spoken at length, almost all of these scenarios hold a remedy under our current judicial system to redraw the districts, to fix those districts, but not eliminate them. Unless the city can find a constitutional flaw like Greensboro did. In the law itself, the only remedy, if successful, would be to redraw the districts, but not eliminate them. Next, as we've talked about, there is substantial legal cost with these things, and there is certainly no guaranteed outcome with any type of lawsuit. Finally, as we said already with amending the charter, election districts, even after a lawsuit, could still be subject to future state action. So that could be, despite the money spent and time invested, not the end of the story if the state chooses to act yet again. Finally, I want to talk very briefly about some combination of these options and what it means if you do one as opposed to the other. If the city chose to amend its charter, that does not preclude you from filing a lawsuit. However, if you amend your charter, you probably, at least temporarily, have eliminated much of the damage that we feel we've been caused by the law. In other words, if we return almost essentially to our old format, there may be very little left to file a lawsuit about. Secondarily, if there is any subsequent action by the legislature, we would again be revested with all the rights that we've talked about today, the ability to amend our charter, the ability to file a claim. It would come back to us yet again, even if we chose to take no action now or limited action now. And finally, filing a lawsuit also doesn't preclude our ability from amending our charter later on as well. That's a right until the legislature takes it away, we continue to have. Now, in thinking of these options, there's a couple of timing concerns that council needs to keep in mind. First of all,
Okay, wait, Brad, before
Yes.
you start, two things. One is just, I didn't say this at the beginning, we're not actually voting tonight. So just procedurally, I just wanted to make sure everyone was clear on anything. We're just hearing from Brad and from the public. And if you came in late, this is the part where we're going to hand out the 3x5 cards, and you can write down any questions you have about the presentation. We're nearing the
end.
I
promise.
The end of the presentation. So staff is going to be handing out some pens and 3x5 cards. So if you, yeah. So jot down your questions. When Brad is done, we'll finish with council questions and take a quick break. So I was just hoping to
Not
give
at
some
all.
little instructions right there.
Not at all.
Okay.
And I do assure the council, I am almost done. A couple of timing considerations which are important. If the city council chose to amend its charter in any way, that process must be completed 90 days in advance of whatever the election is going to be, if that's a general election or primary. Same rule applies. The amendment can be, but is not required to be subject to a vote or referendum in order to go into effect. Such a petition would require 5,000 signatures from the voters to force that petition or force that ordinance to be subject to the petition. With regard to the lawsuits, there is a 3-year statute of limitations on these types of claims, which likely tolls for us, or our period to file them ends approximately June of 2021. There may also be what we call some latches issues, which is just an equitable statute of limitations. In other words, we can't wait forever if we chose to do that. Any final decision on those kind of claims likely would not happen immediately. Our court process, if anything, it is slow, and we may have years ahead of us before any final determination would be made.
And Brad, during that litigation, what is the likelihood that we would get a court to stay the bill so that we could go back to the system we had before?
It is a possibility, and that has happened. That happened in the Wake case. There was a stay granted. Those stays are difficult to get. And I think that it is likely something that happens less often than not in these types of claims. So the assumption, I think, should always be that you wouldn't have a stay and you'd be under the new law until it was finally adjudicated.
So let me ask a question piggyback off of that. So going into, say, next year, if we were to amend our charter within a specific amount of time, that would be in effect. And so if the legislature did not change it back in a certain period of time, you'd have to get a stay for that, right?
If the city council amended its charter and changed it, that's effective.
Right.
Once you've gone through that process. If the legislature doesn't then act, the new charter is in place as amended.
Or if they don't have enough time to act.
Or if they don't have enough time prior to that election, then it remains in effect for that election.
But
No.
that would be the question. So would they consider the election to be, for example, if we chose to put primaries back in, and we did the primaries the way we used to do them, which was like September, and then I think it was September, and then November was the,
It's actually,
was,
October.
Next year's
November.
primary is in March, though.
well, that's the question, though. Couldn't we say that it wouldn't couldn't we? So that's the timing of the next election. When would that be?
This is a difficult question, to be quite frank. You're really, I think, talking about a situation where we get started, maybe do primaries, and then you get a state legislation amending the charter yet again. I don't know that I've seen that, and I don't know exactly what the protocol would be.
This might be one of those follow-up things that needs to be reviewed, because I think, are you saying we would do something where the Board of Elections would conduct the primary for everybody on the ballot for November 2020, And
In
then,
March.
and then we'd have the municipal primary in October, whenever the traditional time is, and then join the general ballot for the general election.
Well, I think it would be according to what the charter amendment said. I mean, we could either choose to reinstate it the way we used to have it, which was October for the
Well,
primary.
I don't know.
Or we could say we want to participate in the primary, the
That everybody else.
the normal.
We'd have to look at it, but I don't remember that the options under the statute for charter amendment get into the minutia of the date of the primary, but.
They do not. The local elections are run by the Board of Election, and we have the ability to install a primary, not install a primary. Dates are outside of our purview on when those are actually occurring. So I don't know exactly how that would happen if you end up with sort of an overlapping action there. That'd be somewhat problematic.
Now, you mentioned something a little bit earlier that I want to pose a hypothetical, and hopefully you can give me an answer. So let's just say we amend the charter and we make it through all this rigmarole, that we actually get through a system where the General Assembly has not re-prescribed something on us, and we actually get through an election where new council members may be elected. You mentioned earlier that after that point, after that fact, something has to happen as far as how the General Assembly has to treat that with those new council members. Can you go back to that and reiterate on that?
So I think I can answer your question. If we amended our charter and we had an election under our new imposed system without the General Assembly acting, those new council members are validly elected under the system that they were put in place under that charter. At that point, the General Assembly could still act, but they could not do anything prior to, in terms of having an election change, until the next election. The city, if it amends its charter, is required to keep that new system in place for 2 years.
And so the General Assembly couldn't act after that point for another,
The General Assembly can act whenever, but if they act after the election, they can't invalidate the election you just had.
that's what I'm asking.
Yes,
Right.
that's right.
And so Brad, if a charter amendment has to be completed within 90 days prior to the election, presumably we would be looking at the March primary date and want to back up.
If the council chose as part of the amendment to have primaries, you would back up from there, and you would need to essentially say 90 days from there is the end of the process.
Right.
The process requires 3 council meetings in order to implement, because it requires a resolution, a public hearing, and then an adoption of the amendment. So essentially, based upon our current schedule, you're really talking,
This year.
yeah, you're really talking 4.5 months to go through that process.
Now, let me ask you one more question.
Assuming the primary would be the same primary as all the other primaries.
My other question would be, for the system to stay in place for at least 2 years for the General Assembly to be able to re-prescribe anything, does that?
Wait, no, wait, we just said it's.
General Assembly can do it whenever they want.
They can do it whenever they want, but if we make it through a final election, that system stays in place for at least 2 years.
No, no, it would, well,
If we do it and we make it through an election,
it would stay in place until the next election.
which would be,
Now, hypothetically, the General Assembly could move the election up
Yeah, they could move
to
it.
even years, but we're really getting into very hypothetical situations. It would definitely exist until the next election,
So
which
here's-
would be 2 years unless they change that.
thank you for clarifying. Here was my question. So would that be a general election or a primary?
It could be either. It could be either, I think. And, when we talk about the election in the statutes, it really isn't making a differentiation between the primary or the general election.
So essentially, we possibly could make it through a primary and then go from there.
It is possible, and if something happened in the interim, it is really a law school question to think about, I think.
And so let's go back to this question of the date of the primary. So what I hear you saying is that we can say we want a primary, we want a primary. We can change our charter to say that, but we don't get to say when that is. So we can't say, we want to go back to exactly what we had before, except for the year, and we want primaries in October and general election in November. The Board of Elections gets to decide that?
Well, Board of Elections runs the process. It is not listed in the state law when exactly the election, if you had a primary, has to happen. So I think we could certainly have some leeway in that. What I think is important is that's not specifically stated in the current law because they've taken primaries away. The Board of Election is really just a ministerial body to run the election. They don't rule, generally speaking, on when elections have to occur. The general election itself follows, obviously, a specific schedule. But I think we would have a certain amount of leeway to determine when the primaries would be.
I mean, the one issue, though, I'm sorry, Julie. The one issue on this, though, too, is that elections are countywide. So what's happened here is we moved to even year elections, and all of a sudden Black Mountain and Montreat and everybody else were like, wait a second, we're going to end up footing the bill because we're going to have to run our own elections. And what ended up happening was they've been now moved to even year elections. So if we change the primary to say our primary is going to be whenever we want it, I mean, first off, there's a legal question as whether or not we can do it. The second question is like, are they going to go run to the General Assembly and say, no, change it back? Because they're then going to have to foot the bill for that primary cost.
These are possibilities. For
So
certain.
I think it's fair to say that we need a little more, we probably need to check around to see what happens if you try to have different primary schedule for elections that will ultimately all end up on the same general election ballot, if that's even a possibility. Maybe somebody here will know and tell us.
Maybe somebody's on the Board of Elections.
Right, maybe right. So, but we know that it's not in 168, 101, that in the list of things that we can.
That is correct. That is
cherry
correct.
pick,
We
right.
have not specifically been given that authority. To close this presentation, just very quickly, I want to go over sort of just some final bullet point legal considerations that I think are important. First of all, the law that is impacting Asheville, which is Senate Bill 813, is very different in a lot of ways that are important from what we saw in Greensboro and Wake County. There are things we can draw from that, but they are very different. We should be careful about assuming that the same rationale applies to us. Second, in a lawsuit, under almost all the claims we've talked about, the court's remedy that they allow for is redrawing districts, not eliminating those districts. It is always important to think about what the prize at the end of the day is, and if that is really the prize you want. Second, or third, the city can, as we've gone through today, possibly accomplish as much or more by amending its charter and do so without the cost of litigation. However, with all possibilities, we remain continuously creatures of the state and subject to future state action. The one element where almost no recourse lies under any of these claims is the ability easily to change the election year. And that's, as we've gone over, not something that's a power that's been given to us on 160A, and it's not something that I've seen any of the case law as being able to shift. So with that being said, I'm certainly happy to stand for additional questions. I will also say again that I would limit myself to not giving any specific legal recommendations or opinions in order to maintain the integrity of any future claim. However, myself, as well as the city attorney's office, does stand ready to research and implement any decision of this council.
Okay.
So for council, yeah, any questions of?
Yeah, I would, a question. Though you said you probably wouldn't advise us one way or another, I sort of feel like you have been. And so three of us have publicly stated that we would like to challenge this, and we would like to challenge all aspects of it. Yet, so I would like to, if a fourth member were to step up and say they agreed with that, you would have some sort of battle plan in mind to fight that.
With regard to taking this into the next step, regardless of the path that council chooses, I would suggest that we start going into more details as a group about the specific strategy. Now, I haven't discussed a lot of those specific elements as part of this presentation. Again, very specifically to maintain the confidentiality we would need for the claim. It's not these people hearing that we worry about, it's the attorneys who would represent the parties that we potentially would be suing, hearing these sorts of things. So council's will is obviously something that we're going to follow and implement the path that council chooses. And we can talk more specifically in the appropriate forum about what the exact elements and strategy would be under any one of these claims.
Just something I would like to say is I think it's great that we're doing this. I think it's about a year too late. We've sat and talked about this in closed sessions for for a year, and those of us that wanted to challenge all along, our voices were not heard, and, people were left to come to their own conclusions about how we felt about this. If a year ago we had made this exact same presentation, then we could be reaching out to the public at that point and getting a truer feeling of how they feel that we should move forward. So it's just discouraging the way it's happened up to this point, and that's all I got to say.
Are there any other questions for,
I mean, I do want to respond, though. I mean, with all due respect, we weren't, again, look, we were discussing this in closed session. If we wanted to have a public session a year ago, that's something, that was never asked.
yes, that was never requested.
That was never requested of any of us to do so.
Yeah.
Any of us to do
So
so.
I don't, Brian, I mean, we've been very respectful of one another throughout this process.
It was
and I-
also never brought up that option existed.
Of
We're
course
council
it
members. We should
exists.
bring it up
Yeah,
ourselves.
Anybody could have brought that up. So, right, it is, right. So we came to this conclusion that it was time to have this forum, and everyone was in agreement, and,
We decided to have this forum after, never mind.
does anybody else have any other questions of Brad before we collect 3x5 cards with questions from the audience about the presentation? Anybody else on council? Okay, let's take it's,
Who's going to collect them?
if you'll bring them up to Maggie, and maybe, is Sarah, I thought I saw Sarah. Sarah's in the back. Raise your hand again, Sarah, in the black dress. If you have 3x5 cards to turn in, either give them to Sarah or Maggie, and we'll take, it probably will realistically take about 10 minutes or so
Brad,
depending on
you,
how
Brad.
many there are.
How long is the break?
It's 10 minutes, but it may take a little longer.